Today we are looking at a question where most of you fall into. Are you married with somebody's wife who has never told you that she is married? Or are you married to somebody's husband who has never told you that you're married? Take this example. You leave Kisii and you're married in Kisii. You go to work in Mombasa. For 8 years, you get somebody there, you lie to that person that you are single and not married. When this person, you go and do a wedding, a proper wedding. The woman in the village doesn't know that you have entered into a marriage. Disputes, if they are not there, you'll never know that you are not married officially. Look at another scenario. You're married in this country. Your wife goes abroad to study. The Mzungu in abroad doesn't know that she was married in Kenya. They contract another marriage. They stay there for 10 years. She knows she has not dissolved the marriage that is here. Is that marriage that they contracted abroad valid? You have been transferred to Garissa or to Wajir, where the president the other day opened up a serious stadium. As a public servant, you are lonely. You get a lady there. She tells you she's single. She has never been married. You tell her you're single. You have never been married. You contract a marriage. Is that marriage valid? We look at the law. What does the law say when you marry somebody without that person disclosing to you that they are married? You remember the decision in the Mary Kitani and Linturi matter. Linturi never disclosed that he had married, but he lived in a manner suggesting that he was not married. But them, they never did a civil marriage. We are talking of when you have gone through the Attorney General, you have married somebody and that person. The law talks of capacity, that for one to undergo a marriage, one must have capacity. Capacity means that if you have ever been married under the Hindu law, 2, under the African Christian marriage, those are marriages under churches. 3, if you have been married in the AG's office. Those 3 marriages are monogamous. Today, we are looking at the Hindu law. The law that applies to the Hindu is the law that applies to the Register of Marriages and also the church wedding. My friend, my crew Vivian, went to the Hindu temple. She had to wear like an Hindu and request to get these facts. She got the first Hindu case, the Sheikh in particular. What did Vivian get? Vivian found a case called High Court at Milimani Law Courts. This is MSA versus PKA. It is a judgment of 3rd July 2009 by retired Justice David Onyancha Anasi. What are the parties in this matter? In this matter, the man and the lady got married. It says, on 25th September 1995, there was a wedding that was conducted. It says, the respondent PKA had in her pleadings herein admitted that she did not make any declaration before her marriage to the petitioner on 25th September 1995 that her former husband LSP was dead. So the lady was married, but the husband had gone abroad. This lady felt lonely. I really sympathize with her. For over 15 years, the man was abroad. The lady decided to get married, but she never disclosed to this person who is marrying her that either the husband is dead or there was a marriage that was conducted. On 25th September 1995, the former husband was found to be alive, and her marriage to him had not been lawfully terminated. The respondent in these circumstances lacked legal capacity to marry the petitioner. After 15 years, the former husband is back and finds her wife has been married. Raises this matter to court. So the question is there. What are the legal consequences? Is that the purported marriage between the parties herein was not only illegal and void, but a nullity, and therefore liable for nullification. Paragraph 12. The petitioner was not by 25th September 1995 properly aware of the respondent's marital status and its consequences on his intended marriage with her, with the most probable likelihood that he would not have proceeded with the marriage had he been made aware of the same before the marriage was contracted. The respondent's failure to inform the petitioner amounted to fraudulent misrepresentation, negative as it may have been. She never disclosed that she had a husband who was away, and that husband has not died, or that husband, their marriage has not been dissolved. So the judge is saying this is fraud, a fraudulent misrepresentation. Paragraph 13, that even if the petitioner may have had full knowledge or awareness of the respondent's marital status before contracting his marriage with her on the 25th September 1995, nevertheless, this would not in law have salvaged the subsequent marriage which was entered into contrary to the express statutory provisions, and therefore it was null and void and against the public policy of England and Kenya. The judge was very, very clear. Whether you are told, whether this woman told the man that let me disclose to you, I'm married, but my husband left her on. So long as that marriage has not been dissolved, that woman has no capacity to marry another marriage. The judge moves on to say, paragraph 14, the facts and circumstances which led and produced the long marital cohabitation and representation to society of the existence of a marital marriage between the parties herein arise from and thrive in an illegal, bigamous, and void contract of marriage. A possible presumed marriage from those circumstances cannot be enforceable by this court, and that would amount to aiding a party who entered a marriage contract which is illegal, immoral, and contrary to public morality. So you have seen this marriage was conducted under the Hindu Act. Paragraph 7 says, the Hindu marriages are in Kenya governed by the Hindu Marriage and Divorce Act, Cap 157 of the laws of Kenya, as read with the Matrimonial Causes Act, Cap 152 thereof. The former act sanctions Hindu marriages to be performed in accordance with Hindu customary or religious rites and recognize existing of two ceremonies, Saptapadi and Anad Karaj. The respondent and petitioner must have applied one of the two, being the Hindu. That the registration of Hindu marriage as provided in section 6 is important for proof that marriage took place, but registration is not the only means of providing this evidence. What is the importance of this matter? The lessons learned from here is that very many people are in a marriage that is called a null and void. A marriage where your partner has never disclosed to you that she is married. Cases abound. People enter marriage, they separate because they differ. They go for 20 years. You think that marriage has collapsed. Have you filed a divorce to dissolve that marriage? Whether you go for 50 years, if you did a marriage, you are still married to that person. Whether you hate him or you hate her, if there was no marriage conducted, whatever ceremony you are conducting is null and void. In this marriage, the Hindu marriage, this was a marriage of 1995. It was dissolved and was declared a nullity in 2007. The lessons learned here is that always do due diligence. Under the Marriage Act, the Registrar of Marriages has a register like NTSA. You can check whether Vivian is married. If she's not married, then you can marry. Okay, Dan Sanomari getting it to you that it does not matter how long you have separated from somebody or how long you ran away. That person remains your wife, that person remains your husband until a marriage has been dissolved. And the only court that dissolves the marriage is a magistrate's court and the high court, not any other village. Whether you returned dowry, whether you did what, that the law does not recognize. Wakili Dan Sadomari, thanking you for being our loyal follower. You are one of our subscribers in YouTube. 70 strong, 70,000 strong. We thank you and we will undertake to give you the best legal discussions that are nerve-wracking. Wakili Dan Sadomari.